Okay, we're up to 169. Can I just explain that there are no Manchester United memorabilia around me, which I know disappoints some of you, but I didn't have time to put my Sir Alex Ferguson picture up. So I've got a fairly boring blank wall behind me in Chambers, so apologies for that. Okay, I think we're almost there, 199, 200. Okay, we're up to 212. I think I'm going to make a start because we're now 3 minutes past 11, and hopefully we're only dealing with the introduction for the first few minutes, so those still joining hopefully will be able to catch up reasonably quickly. Can I firstly thank you all for registering? It's obviously been a very popular webinar. I say we're up to 216, and I know there's several more people still to book in. This is obviously a seminar that has been brought forward quite quickly because of recent changes brought in by the government as to the lifting of the possession claim stay. And it's something that clearly people are concerned about to make sure that they get it right, particularly in respect of notices. So that's why I suspect it's been very popular. In terms of who's going to be speaking today, you'll be glad to hear I won't be very much. I'm just chairing the matter because I'm the eldest, I think. But you'll have the pleasure of listening to Alex, Christina, Olivia and Rowan. And it does feel a little bit like, for some of us anyway, The Big Bang Theory and Howard Wolowitz, given that there are two doctors, but it is hopefully going to be an entertaining session, and also a session that more importantly clarifies a lot of the issues that have surrounded the question of the stay of the possession claim. But those are the speakers you're going to hear, all from housing team here at Cornerstone Barristers. What we're going to be dealing with, I'm going to give a short introduction as to where we are and why we are at this stage. We're then moving on to Alex, who's going to be talking about the Practice Direction 55C, in other words, what in practice has to happen once the stay is lifted on the 20th of September. Christine is going to be looking at the vexed question of notices, and some of you will have seen a table I sent out on social media, LinkedIn and Twitter, trying to explain the rather complicated amendments to Schedule 29. Olivia is then going to deal with the hearings, and some of the guidance there have been produced in respect of how we're actually going to have possession hearings and when. And finally, we're going to end up with Rowan, who is dealing with the vexed question of homelessness, not least in terms of the prevention duty and the fact that, for example, the Section 21 possession claim is clearly something that is no longer treated in exactly the same way because of the extension of the notices. And then we're going to have a chance to have any questions that you want to type in, and if they haven't been covered already by the speakers, we can deal with at that last point. I'm guessing that the speakers will have all finished certainly by 12 o'clock, and therefore there will be half an hour afterwards to ask any questions. So it's my start in dealing with the matter, and firstly to say that, of course, the stay was introduced as a response to the lockdown in March, and it was first a fairly straightforward stay for 90 days from the 27th of March 2020. I say straightforward because there was a practice direction, that's 51Z, that was introduced to bring that in. There was a lot of concern as to whether that's sufficient to have a practice direction as opposed to a rule or amendment to statute. And that practice direction itself was amended in the middle of April of 2020 to reflect certain exceptions, such as trespasser hearings and injunction hearings. And then, of course, when that was coming to an end, we had the second stay, which was meant to be the final stay, and the CPR 5529, which you see in your white book today. That's still there, although has been amended because of recent events. And that stay, of course, applied to all claims issued before the 23rd of August, or before 22nd of August. It had been announced by the Secretary of State that it would be the final stay, but as always, that was not shown to be completely true because we had that extended on the 21st of August, which I think was a Friday, because it's normally a Friday, when it was extended to the 20th of September. I think the thinking is that this is very much the final stay, not least because they brought in, as Christina will explain, the changes to the notices and Schedule 29 to the Coronavirus Act 2020. So it's anticipated that that's going to be the final stay. It's also worth mentioning that there has been a working group under Mr. Justice Knowles, which has been looking at the practicality of returns, but this is very much politically led as to how matters proceed. The question of people in genuine difficulty with rent arrears, and of course the problem of antisocial behaviour affecting both tenants and victims of antisocial behaviour. It's just a quick letter to show that the judiciary and the CPRC wasn't especially happy by the last minute extension on the 21st of August, because it was all rather rushed and all rather panicked, and it was all rather unnecessary because it was fairly obvious what the issues were, and that if they wanted to do something so that you could be a bit more nuanced as to what was stayed, you could easily have done it as they have done now by changing the notice rules. But that was the Master of the Rolls' letter of concern, saying we're just about by a majority agreeing the changes. And in terms of what the impact of the stay, there is some confusion here amongst some people. And it's simply to say that there was no, and never has been any direct impact on injunctions. And that was made quite clear in later amendments to the changes. So injunctions have proceeded as before, closure orders have proceeded as before, often in person. I know, for example, Alex has done a couple of those in the magistrates' courts, and they have proceeded as before. So injunctions are available and have always been available. Of course, they're affected by the difficulties of actually getting hearing dates, and actually the question of remote hearings and whether that's appropriate for all the parties, etc. But injunctions have proceeded. Possession claims can still be issued. There's never been a bar on issuing the claim. The point has been is that once the claim is issued, it is stayed. But there are plenty of claims, therefore, waiting for the lifting of the stay on the 20th of September, which have been issued, and Alex will explain what happens to those. Case management directions have always been able to be agreed. You may argue what would be in it for the defendant to agree case management directions, and wouldn't they be better off dealing with those after the ending of the stay, which of course has some merit to that argument, but you can agree them, and I've certainly agreed case management directions in possession claims and had them ratified by the court. Pre-stay directions are effectively suspended. In other words, if one was meant to do witness statements by the 20th of April and that hasn't been done, well, that will have to be renegotiated and reordered after the lifting of the stay. It doesn't affect claims against persons unknown, and I would just stress that that's likely to be where it's only against persons unknown. If you've just got a second defendant, but you've got a main defendant who is named, it's unlikely that that takes you out of the stay provisions, and also interim possession orders are not affected by the stay. And as I said right at the start, there has obviously been an impact on homelessness. And of course, one of the points about the work around the pandemic and housing was to take, for example, rough sleepers off the streets. And tremendous efforts were made, to be fair, by the government and by local authorities and by housing associations and the charities helping people in those circumstances to make that happen. And a lot of work went into that. There is concern, as Rowan will explain, as to whether that will continue. But clearly, it's not just about possession claims, it's about homelessness. But we'll see that that may be in the minds of the courts as we go on. It's also important to note that certainly at the start, there was some concern as to, well, how far does this stay operate? So, for example, does it operate in respect of appeals? There was the case of Okoro, you see there, Hackney and Okoro, which was one of those judgments where you get the impression, with all due respect, that the decision was made and then they had to think of a reason for it. It's only really one paragraph that's any relevance. And what the court really said was that, yes, appeals are affected. So if you're appealing against a possession order, you are subject to the stay. And the argument that, well, it's only Part 55 that stayed, not Part 52, which is the appeal civil procedure rule, was not accepted by the court, who said effectively once Part 55, always Part 55. There's been the recent case of Werner, which is to do with the stay of execution pending an oral application for permission to appeal, where there wasn't actually an appeal due, but there was an application for permission to appeal due, and the court decided on the facts in Werner that they would adjourn the matter till that date. I think was, I'm just checking here, I think it was sometime in November that they were going to have that hearing. So that's been adjourned to, I think it was the 8th of November. And there's been other authorities like Copeland and Bank of Scotland, where their stay was lifted so that judgment could be handed down, but then enforcement was stayed. Proceedings to issue a warrant were also subject to the stay. That was in the original practice direction, which you saw in the earlier screen, 51Z, and it's also included in the current wording, which talks about all enforcement proceedings by way of writ or warrant of possession. So if you're seeking permission, for example, to issue a warrant, that will be affected by the stay. Of course, in practice, sheriffs and bailiffs have not been carrying out evictions, and therefore there has been no evictions and will be no evictions until after the 20th of September. And even then, the likelihood is that there will be no evictions for some time. The last reference, I would just caution a little bit, because as always with these quick moving things, the dates change. And that date you see there of the 23rd of August as to when 14 days notice will be required has been moved to the 20th of September because of the extension of the stay. So it should read also 14 days notice is required writs warrants of possession from the 20th of September 2020. That's because of the new rule 83.8a. Not particularly impactful for a lot of the London courts, where they would often take a lot longer than 14 days anyway, but it will affect other parts of the country where perhaps the evictions were quicker, and it will affect sheriffs, where of course they were quicker, which is one of the reasons why sometimes people transferred to the High Court for the purposes of enforcement only, but they have to give at least 14 days notice, which I think most people would accept is a sensible and rational step. So that's where we are now. We are in the middle of the stay period. We are, although coming to an end to it, we're unlikely to have it extended. And therefore the real question is what's going to happen on the 20th of September? And I'm going to pass you now to Alex, who will be describing what the courts have said you must do from the 20th of September. So Alex, over to you.
Thanks, Andy. If anyone is having difficulty hearing me, just let me know however you can. So post-stay requirements then. These are set out in Practice Direction 55C. The best way to see this practice direction is as a transitional set of provisions that aim to manage the court's return to normality after the stay ends. This practice direction was created in July. It's been enforced since the 23rd of August. And what it does is modify Part 55 on possession claims during what it describes as the interim period. And that interim period runs from the 20th of September 2020, which is when the stay now ends, until the 28th of March 2021, so just over 6 months. And the practice direction creates 3 categories of case. Firstly, there are stayed claims, so those that were brought on or before the 19th of September 2020, and those include appeals from a decision in a stayed claim. New claims that are brought on or after the stay ends on the 20th of September this year. And the third category of claims brought on or after the 3rd of August 2020. And as we'll see, particular rules apply to that category of newer claims. And broadly, what the practice direction does is 3 things. Firstly, it requires that you reactivate stayed claims once the stay ends. Secondly, it requires that parties provide specified information in possession claims. And thirdly, it creates new rules for the fixing of hearing dates. And that's something that Olivia will touch on briefly in her talk a little bit later on. So we're on to the next slide then, please, Andy. Thank you. So reactivation notices then. This requirement is set down by paragraph 2 of the practice direction. Stayed claims don't simply bounce back to life on the 20th of September when the stay ends. You need to serve, or at least one or more parties has to serve a reactivation notice in order to get the case moving again. And paragraph 2 requires a reactivation notice to be filed and served in order to list, relist, hear, or under CPR 55.15, refer the case to a judge. There are a couple of exceptions to this. The requirement for reactivation notice doesn't apply to claims that are brought on or after the 3rd of August 2020. So those newer claims, you don't have to submit a reactivation notice to get moving again. You also don't have to submit a reactivation notice in relation to claims where a final possession order is made. And that would seem to suggest certainly that if you are applying to enforce a warrant in respect of a case where a possession order has already been made, then there's no need to file a reactivation notice there. Where you are required to file a reactivation notice, you have to do that by the 4 p.m. on the 29th of January 2021. In order to avoid a longer indefinite stay on the claim. Now, importantly, paragraph 2 is clear that a failure to file a reactivation notice is not a sanction for a breach. So in the event that you fail to file on time that notice, you don't have to make a formal relief from sanctions application, which I think for landlords is going to be very important. So next slide then, Andy, thank you. What's the content of reactivation notice then? Well, there's no particular form that the notice has to take, but it does have to satisfy, or it does have to contain 3 things. Firstly, the notice has to confirm, obviously, that the party filing and serving it wishes the case to be listed, relisted, etc. Secondly, the notice has to set out what knowledge, if any, the party has as to the effect of the pandemic on the defendant and their dependents. So a clear indicator, for obvious reasons, that the court will want to take that information into account where possible, and so it needs that information as soon as it can get it. And thirdly, in rent arrears claims, the reactivation notice has to be accompanied by a rent account for the previous 2 years. Additional rules apply in relation to cases where case management directions were made before the 20th of September 2020. In those cases, along with the reactivation notice, you have to include a copy of the last directions order. You also have to include new dates for complying with directions, i.e. dates that have been recalculated, taking account of the stay. You also have to include a draft order that contains any alternative or additional directions that you're asking the court to make, or in lieu of that, a written statement that new directions aren't necessary and that any existing hearing date can still be met. And finally, you also have to include a written statement as to whether, in your view, the case is suitable for hearing by video or audio link. So that's an important indicator that remote hearings, at least for the foreseeable future, during the interim period, will continue where they can, And so the court is seeking the parties' views on whether a particular case is suitable for remote hearing or not. If another party disagrees with what is said in a reactivation notice, then they have 14 days from the service of that notice to respond. We come on then to specifying information, which is a further requirement of the practice direction. These requirements are set out in paragraph 6 of the practice direction. And paragraph 6 applies to any claim that's brought on or after the 3rd of August 2020, so to these newer possession claims. What paragraph 6 requires is that you bring to the hearing 2 copies of a notice, and this notice has to contain 2 things. The first is that it has to contain a statement if the pre-action protocol for possession claims by social landlords is applicable, a statement that the claimant has complied with that pre-action protocol, and also how the claimant has done that. And it also has to contain what we saw earlier, that information, the knowledge, if any, that a party has as to the effect of the coronavirus pandemic on the defendant and their dependents. The third thing paragraph 6 requires is that the notice, those notices be served on the defendant not less than 14 days prior to the hearing. And similar requirements apply with accelerated possession claims. Here, the claimant has to file with the claim form that notice setting out the knowledge that they have as to the effect of the pandemic on the defendant and their dependents. So similar duty, but provide that information with the claim form. Now it's important to remember, and we're on to the next slide, Andy, thanks, that it's obviously in a landlord's interests to comply with this practice direction, to serve the information when they need to if they want the claim to get moving again. But we bear in mind CPR 3.10 here. If you get it wrong, the position is recoverable. CPR 3.10 provides that where there's been an error of procedure, then that error doesn't invalidate any step taken in the proceedings, and also that the court can make an order to correct that error. So if you want your claim to progress, and obviously landlords will want their staged claims to progress as soon as they can and as quickly as they can, then it's in a landlord's interest to comply by filing that reactivation notice where they have to and by providing that information. But it's not, as we saw earlier, it's not a sanction if you don't. You don't have to make a formal application for relief, and 3.10 allows the court to correct any error, such as failing to file a reactivation notice in the course of the claim. So it's not the end of the world, but obviously, as I said, it's in a landlord's interest to comply if they want the claim to start moving again as quickly as possible. And so finally, over to Olivia, and that is me passing the baton and her receiving the baton, and so over to her.
Thank you, Alex. Good morning, everybody. So I'll be talking about listings and hearings. So there are 5 headlines that I want you to take away from what I'm going to say. Unfortunately, none of them are terribly good news, but to be forewarned is forearmed, so hopefully it will be helpful. The first is that you should be expecting a longer wait for hearings if and when you do actually get a hearing listed. Secondly, you should be expecting that if you are listed for a hearing, that hearing is likely to be taking place remotely unless there's a good reason for it not to. Thirdly, there's likely to be a significant added administrative burden, and that comes from both the new prescribed requirements that Alex has just set out for you, but also by the kind of overarching increased requirement for you as landlords to be more proactive, both with the listing process and also with some suggestions that I'm going to make in a few minutes for possibly reviewing your policies and also making use of witness statements. Fourthly, you should be expecting more adjournments in most cases. And finally, prioritization. And that means prioritization both by the court as to which cases it's going to list and when, but also prioritization by landlords as to which possession claims it is worth your time actually pursuing at the moment. Next slide, please, Andy. So, hearing dates. So the court must give at least 21 days notice of any hearing listed or relisted as a result of the reactivation notices that Alex has just explained to you. And the other significant change is paragraph 4 of Practice Direction 55C, which applies to all claims where no hearing has been listed already. So that means stayed as well as new claims. And paragraph 4 modifies the existing general rule that there will be a period of 8 weeks between the issue of the claim form and a hearing. So the new rule for the interim period is that the court will fix a hearing date when or after it issues the claim form. The reason for this change is obvious. It's necessary to allow the court to deal with the huge backlog that it's going to have. But for you, it means that you should be expecting a delay. And you can get a sense of how bad that delay will be depending on the type of case that you're dealing with. The coronavirus guidance for landlords and tenants is clear that the court will be prioritising urgent cases. And by urgent cases, it means antisocial behaviour, domestic abuse, or fraud. So if your case does not fall into one of those categories, you should be expecting to be given a date either very far into the future or possibly not at all for a while. There's also the backlog of cases such as suspended directions that will have to be dealt with once the stay is listed, that you'll be behind in the queue. Next slide, please, Andy. So expect more adjournments. You need to have in mind the context that the court is likely to be reluctant to want to make eviction orders. And there are 2 cases in which you're at particular risk of adjournment. The first is if you haven't complied with the new prescribed requirements under Practice Direction 55C that Alex has just explained. And the second is, as I've already set out, your case does not fall into that category of urgency. The other thing that is of great significance here is the knock-on effects of there being no duty solicitor, and that really ties into the likelihood of more adjournments. So judges are likely to be very cautious about making early determinations because tenants will not have had access to the advice of duty solicitors. You will all already be well aware that judges are idiosyncratic and no 2 judges will react to the lifting of the stay in the same way. But as a general rule, it's sensible to assume that they are likely to be very cautious. And there are 3 circumstances in particular in which caution is particularly likely. The first is where it appears to a judge that it's necessary to allow a tenant more time to seek advice. The second is if, for example, a tenant has not complied with directions and that it appears that the reason they haven't done so is because they did not have access to the advice telling them what they were meant to do and by when. And finally, if it appears to the court that there's even the slightest possibility of a defence, such as disrepair or public sector equality duty, no matter how flimsy that might be, judges are likely to use that as an opportunity to adjourn. So if you are lucky enough to actually be listed for a hearing, as I've already said, it's likely that that hearing will be a remote one. And the one thing that you really have to have in mind if that does happen is, are there any particular issues in your case that mean a remote hearing is not suitable? And the most likely one to arise in practice is probably that the tenant won't have access to the necessary technology to take part in a remote hearing. And I believe, correct me if I'm wrong, Alex, but I believe that Alex is doing a trial in person for precisely this reason soon. And if you are aware of any such issues, then you should make the court aware of those issues. As I set out on the slide, you're also entitled to make written submissions to the court if you think the proposal for a remote hearing is not suitable, and set out what you think would be a more suitable way of going forward. Beyond that, unfortunately, I don't have many practical tips for how to actually conduct remote hearings other than a piece of general advice, which unfortunately is the theme of my talk, about being forewarned, being forearmed, and that's to expect that there may well be issues with the technology. And I set out a quote there from the Civil Protocol on Remote Hearings, urging all the parties involved to be sympathetic to the issues that will inevitably arise. But hopefully if you set your expectations with those kind of issues in mind, then you won't be disappointed if there are difficulties with witness handling or something similar. So with all of that in mind, how can you practically best prepare for the lifting of the stay? The first really key piece of advice is to ensure that you have complied with all the procedural requirements. So all the things that Alex has told you about in Practice Direction 55C and all of the existing requirements that are still in force. The judges are likely to be very cautious about making determinations, and you want to minimise their opportunity to find a reason to adjourn your case. You also need to be realistic about the likelihood of your case progressing. For example, if you know that there is a disrepair issue, then adjournment is almost inevitable. It's also a really good opportunity for social landlords to review their policies on possession claims and think about the point at which you issue possession notices. For example, it may be worth your while changing your policies and making your default position only to issue a notice where you have tried other ways of resolving the matter and the tenant just has not been cooperating. Advice to all landlords is to think about using witness statements when you serve your claim. They don't need to be long, 3 or 4 paragraphs. There are a number of reasons why this might be helpful to you. For all landlords, it's a good way of showing the court that you have complied with the relevant requirements, such as the prescribed requirements for notices. And also, it's a way of showing that you have complied with the non-statutory guidance, like the guidance for landlords and tenants that I've already referred to. So, for example, that guidance says that landlords should consider whether mediation is appropriate. So if you have considered that and it isn't appropriate for whatever reason, then set that out. Similarly, the non-statutory guidance also encourages landlords to attempt to resolve disputes without the need for court action, such as by repayment plans. So if that is something you've tried, then set that out in a witness statement and explain why it hasn't worked. This is particularly important for social landlords because there is more pressure on you given the context of the pandemic. So it could be a useful way of acknowledging that context, but showing why, despite that context, your case is one that still needs to be dealt with now. And so feeding into that, and I've kind of already touched on this, set out all the ways that you've tried to resolve the matter already. So any letters that you've sent to the tenant, any visits that you've made or contact that you've had with DWP. But also you really want to be on the front foot. So if you are aware that, for example, the tenant has mental health issues, which could raise a public sector equality defence issue, then set out in a witness statement how you have had regard to that factor and how it hasn't changed your decision to seek possession. Finally, what's next? Well, more guidance is set to be published in advance of the possession proceedings starting again. But at the moment, the key document is as set out on that slide, and as I've referred to already, the coronavirus guidance for landlords and tenants. Other documents that it's worth familiarising yourself with is the civil protocol regarding remote hearings, and also the HMCTS guidance on telephone and video hearings during COVID. I hope that's been helpful, and I will now pass on to Christina to tell you about notices.
Good morning, everyone, from me as well. My brief talk will be covering 4 things. First, I will go briefly into the basics of the changes that have recently been introduced. Then I will hopefully present in a straightforward way the general rule and the exceptions to the rule before making 3 more general observations and then listing a couple of helpful resources that you can consult after this webinar. And I think one of them is the link to the non-statutory guidance that Olivia has been referring to as well, so that you have that on hand. If we can go to the next slide, please, Andy. Thank you. And I think you need to click one more time because of the way in which, yeah, thank you. So the first thing to say is that the new changes apply across the board, so that they're applicable to both private and social tenancies, and they apply to all common standard types of tenancies. They do not apply to any notices issued before the legislation came into force, and I believe we had one question already about that. Notices that were validly issued and served prior to the changes coming into effect in March this year, they remain to be valid, but obviously do double check that they haven't expired under their normal timelines. So the period that we currently find ourselves in is then very much the 29th of August of this year until the 31st of March of 2021. And that's when the notice periods that I will now be discussing apply. Next slide, please. Thank you. So these apply to all possession claims for housing and land, not to those against trespassers that are brought under Part 55 of the Civil Procedure Rules. What you can do at present, so today, tomorrow, this week, is to issue a notice. So the deadline of the 20th or 21st of September does not apply to that. So you can issue a notice at the moment. What you cannot do is to progress the claim further with the court. That you can only do from the 21st of September. One more click, please. Thank you. So the initial period covered the 21st of March 2020 to the 28th of August of 2020, and there the notice period was 3 months. In the sort of new era that we currently find ourselves in, there is a golden rule. And the golden rule is that if none of the exceptions that I will be taking you through very shortly, if none of those exceptions apply, and if the effect of the Coronavirus Act 2020 has not been suspended, which it has been for certain types of grounds, then the default position is that the notice period will be 6 months. You may have seen different tables online, and Andy has obviously provided a very helpful one, different blog posts on this issue. In order not to get lost in the different types of notice periods, I would just encourage you to remember that the default position is 6 months unless an exception applies, and I will now go to the first out of 3 exceptions. Thank you. So the first exception is antisocial behavior, domestic violence, rioting, or having provided a false statement. And there are 4 different grounds or clusters of grounds under this first exception. The first one of those is for assured tenancies, where you're seeking possession under grounds 14ZA, 14 or 17 of Schedule 2 to the Housing Act of 1988. There you have a notice period of 2 weeks. Where you are dealing with a regulated or protected tenancy and you're seeking possession on antisocial behavior grounds, the notice period is 4 weeks. It is also 4 weeks for secure tenancies where you're seeking possession under grounds 2ZA, 2A or 5 under Schedule 2 of the Housing Act of 1985. So again, 4 weeks notice. And then finally, you also have 4 weeks notice for introductory or demoted tenancies under the Housing Act of 1985. So that is the first exception. So again, remember, if that first exception doesn't apply, we go to the 6 months default. This default period also does not apply where you have rent arrears in excess of, it's worded slightly differently for different grounds, but essentially where you have at least 6 months of rent that is unpaid. You don't have the default 6 months notice period, you have a 4 weeks notice period. There's an exception to this exception, of course there is, so it does not cover case 10A under the Rent Act of 1977. Here you will have a 3 months notice period. And then we can move on to the third and final exception, which is where a tenant has passed away or is in breach of immigration rules and does not have a right to rent a property in the UK. So that's under the Housing Act 1988. You also have a 3 months period. Moving on to the next slide then, please. Thank you. So another thing that is important to bear in mind, so I've said throughout that the 6 months is the default period unless one of the 3 exception categories apply. However, one of the other changes that have been brought into force is that some of the changes have been suspended for some grounds, including grounds 7A and 14 of the Housing Act of 1988. What does that mean? If the changes under the Coronavirus Act 2020 have been suspended for a ground, it means that we revert to the ordinary notice period that you would already be familiar with prior to the pandemic. So by way of example, a ground 14 notice may state that proceedings may be begun immediately, as has ordinarily been the case for ground 14 notices. And the same is the case for ground 7A. Again, we revert to the pre-Coronavirus Act situation, and we must allow 28 days if it's a periodic tenancy, or 1 month if it's a fixed term tenancy. And I've listed here the grounds that are also subject to the suspension. I wanted to make 3 final points before giving you the resources. Next slide, please. Thank you. So 3 final observations. The first is that the non-statutory guidance that Olivia mentioned, and which the link of to which will be on the next slide, recommends that you should, where you are issuing a new notice of the same type. So if we're imagining a situation where now the new rules that took effect in late August of this year give you a shorter notice period than what you would ordinarily have had prior to the new changes coming in, you can essentially swap them, but you should withdraw the first notice prior to serving a new notice. The second point is that the government has extended the period over which valid Section 21 notices remain valid, where it's done under Section 21(4)(d). It's 10 months from the date it is given to the tenant, and where Section 21(4)(e) applies, it's 4 months from the date specified in the notice as the date after which possession is required. And then the final point that I just wanted to make here, and that's something that Olivia mentioned briefly as well. The guidance mentions that obviously seeking possession is something that is currently discouraged by the government. And so there's a little bit of an emphasis in the non-statutory guidance about exploring other options, perhaps more so than you would ordinarily do, with a specific emphasis on exploring mediation. And that brings me to my final slide, which is really just the links to, well, one, the House of Commons briefing paper, which is quite helpful, and then the non-statutory guidance, and both of them, I believe, have, they discuss certain scenarios, sort of real life questions, and answer them, as well as giving you a little bit more context to some of the things that we have talked to you about today. And with that, I hand over to Rowan. Thank you.
Thank you very much, Christina, and good morning, everyone. I'm going to move straight on to my first slide to ensure that we try and leave some time for questions, because I know that a lot have come in. So if we could move straight to just the priority need and COVID-19 slide, please, Andy. As you'll know, consideration of priority need is important in this context, as it's a gateway to accommodation either on an interim basis or under the full housing duty under Section 188 or Section 193 of the Housing Act 1996, respectively. As you know, one of the ways in which a person will be in priority need is where they're vulnerable as a result of old age, mental illness, a handicap, or some other special reason under Section 1891C. The relatively recent health protection coronavirus restrictions #2 regulations includes a definition of vulnerability, which I think will have some bearing on this assessment more broadly. At its regulation 1.5, the regulations provide individuals will be vulnerable for the purposes of those regulations if age 70 or over, or if they have an underlying health condition of the kind set out within Schedule 1 of the regulations, or if they're pregnant. Now, moving to the next slide, thank you, Andy. Here within Schedule 1, you see a list of the conditions which will qualify an applicant as vulnerable under the regulations. I'm not going to read them all out, as I think these slides will be accessible online eventually, but you'll know that the list is identical to the government list of conditions which will qualify someone as clinically vulnerable. In short, the presence of any of these conditions with reference to the regulations will be a factor indicating that an applicant is more likely, or should more likely, be found to be vulnerable as understood by section 189, and therefore owed the corollary duties under section 188 or 193. There's been further assistance or guidance on this issue by amendments to the Homelessness Code of Guidance under sections under paragraphs 844 and 845 of the Homelessness Code of Guidance. Now, firstly, clinically extremely vulnerable people are said in the guidance to be likely to be assessed as having priority need. Now, such persons are obviously those who have been advised to shield during the pandemic as being at the greatest risk. And examples include people who've recently had solid organ transplants or are undergoing active chemotherapy. There's a distinction, of course, between the group of people characterised as clinically extremely vulnerable and those who are characterised as clinically vulnerable. That's in effect the next tier down, as you'll recall from the list Schedule 1. Those are people who are still at higher risk of severe illness from coronavirus, but the guidance is slightly different from those who are clinically extremely vulnerable. The guidance for people who are merely clinically vulnerable is that where a person has such a condition, it's vital for their need for accommodation to be considered in light of that condition. And obviously, again, it's a factor in favour of making a finding of vulnerability. Now, finally, I note that in the event that an applicant represents in their application to be extremely vulnerable or clinically vulnerable, but doesn't provide sufficient medical support or medical support at all for that position, authorities are encouraged to seek their own assessments. And I pause there, just anticipating future reviews on this point, to note that, in my view, I don't think this is the kind of assessment that's likely to be adequately completed by a now medical referral or anything similar to that. If there's not already adequate medical information to support an applicant's claim, it's difficult to see how a doctor could opine on the clinical vulnerability of an applicant without an examination, in my view. Now, turning to the next slide, on early assistance and the prevention duty, you've heard very clearly from Christina, I think, of the new extended notice periods of 3 months or 6 months in relation to possession claims. It's tempting, I think, given that extended notice period, for an authority to be aware for some time that action to evict a tenant is underway, but then to only provide assistance to that tenant perhaps within the final 56 days of the expiry of the notice period, in line with the prevention duty under section 195 of the Housing Act 96. In truth, however, in the circumstances, there's really a need for authorities to act as early as possible. And paragraph 12.2 of the guidance on duties in cases of threatened homelessness urges authorities to offer assistance where possible, rather than delay providing support, which may be effective when providing or effective in preventing homelessness, rather. Further, the recent non-statutory guidance, a link to which was provided very helpfully at the end of Christina's presentation, encourages tenants to contact their local authority as early as possible in cases in which they're worried about losing their properties. That guidance reminds local authorities of the prevention duty, and it encourages local authorities to intervene and assist in rent issues between landlords and tenants where it's appropriate to do so. It also reminds authorities that they can provide additional support for tenants to stay in their homes, further to which there's some detail on that on the next slide, please. Or the previous slide, rather. Thanks. Yes, as you can see here, page 8 of the non-statutory guidance reminds us that the government have made £500 million available to fund households experiencing hardship. And on the next slide, you'll see that the way in which that funding is to be used is 2 ways broadly. First, it enables local authorities to reduce the 2020 and 2021 council tax bills of working age people when they receive local council tax support. And it also allows authorities to provide further discretionary support to vulnerable people through alternative support arrangements, for example, like local welfare schemes. Now, taking all this together with the previous slide, in instances where an authority receives good notice that a tenant may be threatened with homelessness, and recall that tenants are being encouraged by the guidance to provide that early notification, it seems prudent, firstly, not to delay until 56 days before the expiry of any notice period. Secondly, in the event that the applicant or the future applicant for homelessness assistance is occupying private rental sector accommodation, an authority could attempt to mediate any potential dispute with a landlord with a view to resolving things before possession action is necessary. Thirdly, local authorities could provide assistance to potential applicants to ensure that he or she is being provided with her full benefit entitlement, and to ensure that any potential application for discretionary housing payment, for example, is being made. Fourthly, authorities should consider whether additional supportive funds are available by virtue of the hardship fund. And finally, and perhaps more holistically, authorities are to consider the appropriate level of support that would be necessary to provide in order to avoid possession action and to intervene as appropriate. So moving then to the issue of suitability. It's increasingly unlikely, in my view, that applicants will be able to afford private rental accommodation within the borough from which they apply for homelessness assistance. That's particularly so, obviously, if the basis of previous possession action against them has been for rent arrears. And further, it will often be the case that local authorities will not have sufficient capacity in borough to offer accommodation in light of the current pandemic. I pause to note there that a local authority is entitled to hold back a stock of accommodation, and on that point, see the guidance from the Court of Appeal in one of Andy's recent cases, Olivkiet and Brent. It follows that in-borough accommodation will rarely be suitable at the moment, I think, and out-of-borough placement is more likely to be necessary. As such, and remembering the guidance from the Supreme Court in Zolamiso, it will be useful in such scenarios for local authorities to refer to publicly available allocation policy, which explains the relevant factors that they're going to take into account prior to offering any remaining units within the borough, and explains the factors which will make it suitable to accommodate a household further away where necessary. As such, it might be a good time to review any allocation scheme and to ensure that it's appropriately drafted and clear, such that it can be applied in practice by officers without confusion. Now, you might notice a picture of the microwave in this slide. I apologise for letting things get so heated on a Monday morning. However, it illustrates a further issue in relation to suitability and the coronavirus, and that's this. There may be questions over whether accommodation provided to an applicant, particularly vulnerable to contracted COVID-19, is suitable for that applicant. Now, whether that's so will depend on the fact of the case, and it's important the authority take time to understand the needs of the particular applicant in that scenario. But on the microwave fridge point, it was sufficient in that case, in which an applicant was clinically vulnerable, case of Escott, for an authority to provide the applicant with a mattress and a microwave oven. But there was no need to provide any white goods or a bed, contrary to the applicant's suggestion that those sparse furnishings were insufficient for him to self-isolate at the property. Now, similarly, I think it's easy to envisage an instance in which a clinically vulnerable person or a clinically extremely vulnerable person is very reliant on support from friends or family members, and where proximity to that kind of assistance will be relevant to the question of suitability of the accommodation. So I would encourage authorities to ensure that those factors are considered in light of the issues arising from clinical vulnerability or clinical extreme vulnerability when considering the extent to which accommodation is going to be provided. Turn finally to the slightly optimistically titled slide, The End of Rough Sleeping. You'll remember that in March 2020, £3.2 million was provided to local authorities as part of the Everyone In scheme right before the start of full lockdown. Again, that had been optimistically hailed as the end of homelessness by commentators. It would seem now that the vast majority of contracts between local authorities and the hotels which had been providing interim accommodation for rough sleepers have ended, and no further funds have directly been allocated to keeping the Everyone In scheme alive. But there have been developments since then, and the position is not as dire as perhaps it could be made out to be. £3.2 billion of additional funding has been pledged to local authorities, but that money has not been specifically ring-fenced for alleviating homelessness, and it will not necessarily be spent in that way. And you'd think, given the strain that's on local authorities in the circumstances, it's unlikely to be spent entirely in that way. Further, a fund of £433 million has been announced to provide 6,000 housing units for vulnerable rough sleepers, 3,300 of which are to be delivered within the year. And perhaps most encouragingly, on the 2nd of May, the government announced the establishment of a specialist task force to be chaired by Dame Louise Casey, which is to lead the next phase of the government's support for rough sleepers during the pandemic. Now, further, I'm sure you will have read this guidance already, but on the 28th of May, Luke Hall, MP, who's the Minister for Rough Sleeping and Housing, wrote to all local authority chief executives, advising them of those updates and also providing some guidance in relation to move-on accommodation, which is presumably the accommodation to which people are moving on from that which was provided by drawing on the £3.2 million worth of emergency funds. In that letter, Mr. Hall urged local authorities to encourage people, where appropriate and possible, to return to friends and family following the occupation of emergency housing. He encourages local authorities to seek to find as many sustainable move-on options as possible, so to maximise stock effectively by considering local housing stock, considering partnerships with housing associations, and perhaps by supporting entry into the private rented sector. Authorities have also, with a view to maximising their stock, been asked to consider expansion by the acquisition, repair, refurbishment of existing stock, and the consideration of long-term leasing, which is an option available to authorities. So, in some ways, the position is very optimistic. Funding has been allocated to provide a long-term solution. Equally, there hasn't been a direct extension of funding for the Everyone In scheme, although further funding has broadly been allocated to local authorities. As to the short to medium-term assistance for rough sleepers, I'm afraid we'll have to await the response of the specialist task force. But thank you very much for your attention. I pause to note that if you really want to keep up with developments in this area, it's worth following the Cornerstone Housing account on Twitter, and probably also Andy's Twitter, particularly if you are interested in Manchester United Football Club. So I'll hand back to Andy now, and I think it's time for some questions.
Yeah, I think you've summed up my social media very well, Rowan. Thank you very much. Rowan was a pupil of mine, which is why you can see pictures in his presentation, which I have stopped doing, but I'm normally a big fan of them. We've got a lot of questions. I mean, there is obviously some repetition. I just noticed, because there's two issues, there's Q&As and there's chat. I noticed that James had asked a question, or rather he pointed out quite sensibly that there is an amendment under the Civil Procedure Amendment number 5 rules, removing the requirement for permission of a court for the writ of possession, and then asks, as a result, is High Court enforcement now an option to enforce existing outright possession orders and SBOs? I mean, it's one of those questions which is very difficult to answer. I mean, personally speaking, I don't think it's going to increase the applications, or rather increase the use of High Court sheriffs. I suspect High Court sheriffs are still going to be quicker than County Court bailiffs, especially in London, of course. And there may be reasons why one might want to do that. But I think most landlords, particularly social landlords, are probably quite prepared to wait and go through the bailiff procedure. But it's a very good point, James, and it is worth having a look at the Amendment number 5 rules. Of course, having done this webinar, we're undoubtedly going to get number 6 as soon as we've finished changing everything. But thank you very much for that, James. There is also a whole host of questions, and I think, as probably we weren't too surprised, a lot of them are to do with notices. Now, what I would say is that our last slide have our email addresses, and I'm more than happy if you want to email me at andrewl@cornerstonebarristers.com to send you the table that's been referred to. There are also excellent commentators out there, other chambers, solicitors, and of course, Giles at Nearly Legal has produced an excellent run through of the changes. But I'm more than happy to send out that table by email to anyone who wants it, and please just email me to ask. But just having a look through some of those questions, I'll go to the top, to be fair, for the ones I haven't already answered while failing dreadfully at moving on the display. We had a question, that's about the Wi-Fi. Somebody asked for some guidance on what happens when you had an eviction date, the tenant applied to suspend the eviction, but their hearing wasn't heard due to the pandemic. How do you deal with that case? It's a good practical question. My own take on it is that one should be able to simply relist the hearing, although of course the date in the warrant will have passed by now, but I don't see why you have to get, for example, a new warrant. And I don't see, in some senses, why you have to get a reactivation notice. I don't know if any of the other four, particularly Alex on the reactivation notice point, has any views on whether you need a reactivation notice in that kind of scenario.
I don't think you would. I haven't answered that question because I thought it was quite a tricky one and probably warranted a bit of discussion. I think my instinct on that would be to write to the court to relist the hearing. But of course, if the warrants expire, then you would need another one.
Yeah,
but I don't think it's a reactivation notice issue, as far as I can tell. There's nothing in the practice direction. If a final possession order if a final possession order has been made, there's nothing in the practice direction that would require you to serve a reactivation notice, as far as I can see.
Well, that's certainly my take on it. That this isn't something that was necessarily stayed by reason of the rules at all in any event. And of course, one of the prioritisation cases when the court had, and you may recall priority 1 and priority 2, one of their priority ones was warrant hearings. I mean, okay, you didn't actually get the eviction because, of course, it didn't actually happen because of the bailiffs, but they were still having those hearings. What you couldn't have, for example, was an application for permission to issue a warrant. If, let's say, you'd had a breach of an antisocial behaviour possession order, where you obviously would have to show that the person had breached their order. So in those cases, I think there was a case. But I think the question rather indicates the uncertainty there's going to be amongst courts on this, as much as amongst lawyers and advisors. But my own view is that it's not necessary for a reactivation notice in those circumstances. Somebody's asked me for my email address, but as I say, it's online, by the way, if you want to. I think everything's online. It is andrewl@cornerstonebarristers.com. Will a reactivation notice be required if the claim is issued after the 3rd of August? Well, back to you, Alex. Are you there, Alex? I feel like one of those.
I am. Sorry, yes. No, I'm just having an issue muting and unmuting and things. Will a reactivation notice be required for a claim issued after the 3rd of August? The answer is no.
But there is a paragraph 5.
Paragraph 1.4. Just looking at CPR.
Sorry, but is there a paragraph 6 notice that would have to be issued?
A paragraph 6 notice would, yes.
If you have a look at the practice direction, it's a fairly short document, and they do, as Alex explained well in his presentation, they do differentiate between pre-3rd of August, that's everything up to the 2nd of August, and afterwards. And afterwards, although it may not be called a reactivation notice, there's still a notice that has to be issued under paragraph 6, I think, Alex.
That's absolutely right. Yeah, specified information would. Yeah, that notice would have to be served in the case of a newer sort of post 3rd of August claim.
Somebody asked, in relation to ASB issues led by the police council, what procedures will they have to follow under the current situation, considering there's never been any contact with the tenant or any sort of mediation? I don't know if anyone wants to come in on that. I mean, I think ASB, it doesn't seem to me, has changed a great deal, save that, of course, you haven't been able to proceed with possession claims and you haven't being able to do things as quickly as you would have liked to because of the obvious impact of COVID-19. In terms of the courts wanting greater mediation, I think both Christina and Olivia have mentioned mediation as a possibility, but with ASB cases, those would have been considered in the normal way anyway, under your policies and procedures, and indeed in compliance with any protocol that applies, such as the social housing protocol. Does the stay apply to possession proceedings which are required to evict an excluded occupier who otherwise is refusing to vacate a property? Well, the answer to that one is quite clear, that The stay affected anyone in terms of the Part 55 claims, and so anyone issuing possession proceedings under Part 55, which is what possession proceedings are in general terms, is covered. And indeed, even in a counterclaim, as a recent authority confirmed, that can be a possession claim. So yes, it would be included. The exceptions, as I mentioned earlier in my introduction, were to do with unknown individuals and to do with interim possession orders. But stay otherwise applied, and it was very kind of binary. It wasn't nuanced, and even now the nuances only actually apply in large term to the notice seeking possession. We've asked if we serve a section notice, this is a private landlord now, due to 6 months rent arrears, is it advisable for the landlord to draft a witness statement to show attempted contact with the tenant? The concern here being that a judge may not award a possession order if arrears accumulated over this COVID period. Anyone want to comment on that? I mean, what I would say, sorry,
Sorry, I was just digging out an answer to another question, actually. I wonder if we could just go back to slide 12, because I know that someone's
okay. I will, but can we...
Format for reactivation notices, so I just think it'd be useful if we get slide 12 back up again.
I will do in a minute, but can we just have an answer to this question? I think the reality is private landlords, let's be honest, they're going to have short hold tenancies. They're generally speaking, of course, subject to what the term of the tenancy is, going to issue Section 21 notices. And they're therefore going to use that because the reality is they're unlikely to recover any money anyway. So there's no point issuing a normal N5 claim. So in those cases, you wouldn't normally use a Section 8 notice. But in terms of drafting witness statements for a private landlord, I think it's less important. I don't know if, Olivia, you have any view on that. I think it's less important. The importance, I think, that Olivia was referring to in terms of drafting statements was because, of course, as a social landlord, you not only have a specific pre-action protocol to apply, but the government in their non-statutory guidance would expect certain things from social landlords, which perhaps they wouldn't expect from a private landlord. I don't know if that's your view as well, Olivia.
Yeah, I completely agree with that. I think witness statements are particularly useful for social landlords as a way of just showing that you acknowledge the extraordinary context that we're all operating in at the moment and show how that's informed your decision making. But that obviously doesn't apply to private landlords. And
I'm going back, am I back far enough, Rowan, for your slide 12? I don't know what the slide number is, but...
It's the slide that's titled Reactivation Notices Content. Yeah, that one, perfect.
Right, off you go.
So there you have the format of the relevant content that must be included in a reactivation notice. As I think Alex stated, there's no particular form that necessarily needs to be used, but the reactivation notice should contain that information in order to be valid.
Excellent.
Yeah, actually, just on that, while we're on reactivation notices, I've just answered a question about whether it needs a statement of truth as well. There's no requirement in the practice direction for that.
Excellent. I've got a question about concern as to the court administration, that a case should be prioritised when it's an accelerated claim, but brought because of ASB with no relevant evidence, of course, because it's a Section 21 claim. Again, I suppose you dealt with the question of hearings, Olivia, but as a general statement, obviously, we're reliant on courts, and I suspect what happens in, I don't know, Clerkenwell is going to be very different than what happens in Milton Keynes and what happens in Wandsworth or what happens in Northampton. I mean, it will very much depend on individual courts, I think. And my experience of actually going to court in a trial last week in person is that what they were doing at Clerkenwell, for example, was very different from what I experienced when I went to the RCJ the previous week. So, you know, it's going to be very much impacted by local court practice, but in general terms, what about accelerated claims and ASB? Anyone got any comments on that?
I don't think I could add anything to what you've said, unfortunately.
I mean, I think it's a good point that's been made that there will be people taking these kind of actions. And of course, the Section 21 notice provisions don't take account of why, unlike, for example, introductory tenancy provisions, which do. And they do take account, and it's a shorter notice period if it's for ASB reasons, as an example. But but it's a fair point. It's fair also to point out we don't have an answer to all of these questions because they are new issues which we're waiting to hear. Somebody asked about peak hole hearing dates generated in block listings. How is this likely to be affected by the prioritisation of ASB? Anyone got any comment on that?
My understanding was that the block listing approach to possession hearings has been jettisoned, and that's one of the reasons that you will now get a specific time for your possession hearing. As to the prioritisation of ASB, you heard earlier about the classification of cases. I can only assume that that's the way in which they'll prioritise, the way in which they move through the backlog of possession claims. But I think the takeaway point is that the block listing system is no longer going to be used. Yeah,
I think that's true. And I think that's everyone's experience, even remotely. You know, we're not getting the same listing. That's certainly going to be the case for some time to come.
And I don't know whether that's necessarily a good thing or a bad thing, because I think you might find that at times the block listing system allows judges to juggle things around so that perhaps shorter matters can be dealt with more briefly, and longer matters, which turn out to be more detailed than perhaps they were originally listed for, can be dealt with on the day by the judge providing perhaps more time. But I think with the case being allocated a specific amount of time and the judge's time being sort of set out in that way throughout the day, you might find that things do move more slowly and things are put off.
Yeah, and I certainly think remote hearings anyway, you're not having, you can't do it as quickly. And if you're dealing with litigants in person, I've dealt with a number of litigants in person over the lockdown, and certainly two of them, for example, went off the line. I think one of them may have claimed later it wasn't deliberate, but I suspect it was. But there is an issue. Are they able to, even with a telephone hearing, are they able to adequately deal with that? Are they in the right circumstance? Have they got the right health issues to be able to deal with that properly? And I think judges, as you said, Olivia, are going to be very attuned to anyone who is genuinely struggling to properly engage, whilst also recognising that certain of the grounds that are being pursued may well be mandatory grounds, and therefore there'd be a limited scope anyway to deal with it unless there's a public law or discrimination defence. I've got one for you, Christina, about notice periods for secure tenancies, grounds 1 and 2. I think it just says, how long are they?
So individually, if the rent arrears under ground 1 are at least 6 months, you'd be looking at 4 weeks. And then for ground 2, because it reverts, I think it's you don't have any notice period at all. I think there seems to be some uncertainty as to whether you can combine different grounds within the new framework that we're operating in. I don't know what your view is on that, Andy. I think, I can see that it makes sense to say that if you could only rely on, say, ground 2 and you don't have a notice period for that, why would you suddenly have a longer notice period if you add a ground rather than take it away? But perhaps
I think the answer is, and there was a debate on Twitter, to show I'm not totally wasting my time, about this, and I know that Russell James, who's a great tenant barrister, particularly down in the southwest, had an exchange with Giles about this at Nearly Legal, and I think the reality must be is if you're actually saying that the ground 2 and indeed ground 14 for assured tenancies is effectively suspended the operations of the Coronavirus Act. In other words, it goes back to what it always was. Yeah. Well, it always was the case that as long as you have ground 2 in there, it doesn't matter whether you combine it with something else, you're entitled to issue proceedings immediately. And that seems to me the logic. Yeah. There's always, of course, scope for abuse in that, you have something that, you'd be pushing to describe it as antisocial behaviour. I don't know, supporting Liverpool or something. It's something very extreme just so you can get the immediate thing. I think courts are going to be wise to that, is the reality, and therefore, but I think my own view and interpretation is that if you've got ground 2 in there for a local authority, it's immediate, full stop, whether or not it's combined with other grounds or not. And that's certainly my take on it. And I very much agree with Russell on that. if you wish to serve a notice to quit and are without prejudice, NOSP for subletting, and own your principal home, and maybe arrears too, if any, do we have use 4 weeks notice on both? Just keep it simple.
Which one is that, sorry?
This is Georgina's. Georgina, notice to quit, of course, has never been affected unless it's a Rent Act case, and as been said by Christina, notice to quit, and I've had to answer several of these questions, has never ever been affected by the changes, by Schedule 29 of the Coronavirus Act 2020. It's always been, whatever it is, 28 days, or in monthly tenancies, a month. It's never changed. So if you're going to go down the notice to quit route, you're fine. If you're going to also go down the notice seeking possession route for, I don't know, subletting of part in breach of the tenancy, so, you're doing ground 1 for a local authority or ground 12 for a housing association, then of course, in those circumstances, the normal rules would then apply, and you'd have to go back to the provisions which only really favour, for example, for ground 1, if you've got antisocial behaviour, which is ground 2, which is immediate. So you're going to have the same issue that has just been said by Christina, in that it's not going to be particularly helpful, is it, Christina? I don't think, to go down the notice seeking possession route in such cases.
Mm-hmm.
I mean, how long would you have for notice seeking possession for a breach of tenancy claim under ground 1 of the 85 Act?
Well, if rent arrears are for at least 6 months, then it's 4 weeks. Otherwise, it's 6 months. Yeah,
and of course, it's very clear that and you'll see from my table if you ever get it. 1 to 6, 9, 12, 13, 15, and 16 of the 88 Act, and 12, of course, includes breach of tenancy. It's 6 months period. So you'd have to think in the past where you might have done it in the alternative, whether it's worth doing. So there may be issues there, or maybe dispensing with the requirement for a notice, I suppose, in certain circumstances. Andy, you answered the notice period or notice to quit to be served on non-secure tenancies is 28 days. How long is that notice valid for? A notice to quit, remember, has effect permanently. Unlike a notice seeking possession, which is only a warning to a tenant that, either landlord may take you to court, and it has the normal 12 months life from when it expires. With a notice to quit, it's permanent. Now, I know we've all dealt with cases where there'd been previous notices to quit and nobody's acted upon them, and they've just effectively put their hands over their ears and their hands over their eyes and pretended that there's no previous notice to quit. But a notice to quit has the effect of bringing a tenancy to an end at the expiry, so after 28 days or a month or whatever the period is. That's the legal effect of it. And so there is no lifetime for it because it has effect. Whereas a notice seeking possession, as I say, is just a warning. It doesn't affect the tenancy or anything. Another one, I think, for you guys, notice period for notice to quit. No, I think we've dealt with that. In regards to notice periods, when serving a notice of seeking possession for rent arrears on a secure tenancy, when referring to 6 months of non-payment of rent, is this in the value of the rent owed, or does it mean that the landlord has not received a payment for 6 months? That's a good question from anonymous attendee. Anyone want to answer that?
It's the amount owed, isn't it? Is my understanding.
Yeah. I mean, it could mean that if you're getting most of your rent paid by, the DWP or the local authority in housing benefit, then it could take some time. But yeah.
But the contrary position is ridiculous, isn't it? Because you could pay 3 years worth of your rent in advance, and then the ground would be made up if you didn't pay for 6 months previously. Yeah. And it also means that if you had arrears problems anyway, that goes towards the 6 month period, which will affect the notice period that you're having. And some of these cases, remember, would have had arrears problems even before the coronavirus impact, where they may well have been genuinely impacted by it. I've got a question about serving a notice of possession on an introductory tenant who has been hoarding rubbish and is refusing access and refusing to engage with any support services. Would the notice period in the NOP be 6 months? And the introductory tenancy will become secure unless anything's done in January 2021. Anyone want to answer that? This is section 128 notice, isn't it? Is the notice?
That's the 128 notice.
For introductory tenancy.
I mean, Georgina, I think the quick answer is that most of those are 6 months unless there's an ASB reason.
Yeah.
And it's worth having a look at Section 84 to see what an ASB reason is. But clearly, if you might argue that that's an ASB reason, which may be true. ASB, let's be honest, is normally something that's causing a nuisance or annoyance. So it may well therefore be a 4-week notice, not the normal 6 month notice that would be required in other cases for those matters. How many months' notice to be given to a personal rep? Well, that's 28 days. That's always been 28 days. That hasn't changed for the reasons we've mentioned.
There's another one, Andy, procedural rather, a substantive question. Will the court hear a full trial of 1 to 3 days remotely? I get the sense that it depends pretty much on the court. I was quite surprised actually when I was in Bromley a couple of weeks ago to be told by the judge that even a 2-day trial would potentially be listed for a remote hearing if it could possibly be, on the basis that they only had one sitting judge at the moment, actually physically there each day, and they're trying to cut down in-person hearings as much as possible. We didn't think that was appropriate for a 2-day trial, but that was Bromley's view. So it may be that other courts do things differently. But there's no reason in principle, I would think, why a trial cannot be listed to take place remotely, even if it's more than a day, if the parties are equipped to do it. Yeah.
I mean, I'm sure there will be remote hearings, and if you speak to commercial people, they'll have been doing those trials for even before COVID. I just think it's going to be difficult for a whole host of reasons. I've cross-examined somebody over the phone when they've been at home, and we had to abandon it because she clearly had somebody there with her, and clearly was somebody who was feeding answers, which of course is not appropriate. And that may be a bit clearer if you've got a video rather than the telephone. But again, if you're going to have a video, who's got the facility for that? If they're not represented, who's got the facility? I did have a case management hearing before Judge Luger a few months ago, and when the objection was made by the Law Centre to the difficulties that their client would have to engage in any remote hearing, he basically said, well, they can go to the Law Centre and sit there and remotely distance. So, but if they haven't got anyone representing, it's going to be very difficult. But I suspect there will be those hearings, and I'm sure some of those listening to this will have had hearings listed or indicated that may well be remote. And if the option is that the person can't get to trial because they're in whatever they call it, it's not quarantine, but you know what I mean, then in those cases, what are you going to do? Just wait until they get better, or are you going to proceed? It's a bit of a difficult one. So in theory, I think they can do it, but I think they will try. My experience at Clerkenwell was the claimant had their own courtroom as a waiting room, the defendant had his own courtroom as a waiting room, and we had a third courtroom to actually have the trial in. Now that's not that you can't sustain that full time, because that's 3 courtrooms being used, and nobody else being allowed on the floor because the door is open for ventilation purposes. So yeah, anyone else seen anything interesting? More notices to quit for abandonment? No, that's 28 days still. It's never been 6 months, so don't worry about that.
There's some other precedent notices, new notices to be used. If that relates to reactivation notices, no is the answer.
There are 21 notices, aren't there?
Sorry, I didn't hear that, Andy.
There's a new Section 21 notice, and I suspect there's a new Section 8 notice as well, an 83 notice for the notice seeking possession. So make sure you get the right notices, but I'm sure people are on top of that. Is there anything to prevent a landlord serving a new notice if they had less than 6 months rent arrears on one day, but then had a few weeks later more than 6 months rent arrears? We're going to vote in a minute, aren't we? Anything to prevent that?
I mean, I don't think so. As I said, the non-statutory guidance recommends that you withdraw the initial notice, but there isn't any official formal way of doing that. So it may just be a matter of writing to the individual, informing them of the steps that you intend to take.
Landlords have often issued notices, for example, for rent arrears, and then because of something that's happened subsequent, like antisocial behaviour, have issued a fresh notice. And what they tended to have done is not include the rent arrears grounds in the new notice. They've just added new grounds, and there's nothing wrong with that. You know, you just have to rely then on both notices, of course, in terms of your pleading for the particulars of claim. And as I say, a notice is just a warning, so there's nothing to stop you issuing a notice every day if you want. Please don't, because that might be harassment. But in principle, you could issue a notice every day. You know, so you don't need to. You can't. Yeah, with a notice to quit, it wouldn't have any effect, of course, because your first notice would be the thing that ends the tenancy. So, somebody asked, to be clear, for introductory tenancies with rent arrears, the period is 6 months. Yeah.
Yeah.
Yeah, because there's no ASB reason. If it's an ASB reason, you could have 4 weeks, but if it's rent arrears, there is a problem. And I can see the dilemma with that. Somebody's got their Wi-Fi gone. Has anyone seen any other questions?
One that's coming quite recently, actually. It's from Fabian. Is a tenant not having a laptop, but who has a mobile phone, good reason to ask for a face-to-face as opposed to a video one-day disrepair trial? I saw in an order from Central London County Court last week, obviously for a Skype trial or Skype hearing coming up, the directions about how to log onto it, and it said it's not acceptable to take part in the hearing by mobile phone. I don't know if all courts take that view, but it would seem, I mean, it said that ideally you need 2 screens to do it, so that you can see the trial bundle or the hearing bundle with one screen and then the parties with the other. So I would think certainly if Central London's anything to go by, then if you have a party that doesn't have a laptop, then that is a good reason to ask for a face-to-face hearing.
Absolutely, and it goes back to what I was saying about litigants in person. I mean, even if they've got a laptop, have they got the ability, you know, to actually use it in the manner that, you know, is required? And I know you might say, well, that's just clicking on a link, you know, for Microsoft Teams or whatever the system is, but it's not always that obvious. But we'll see. But yes, I think you're absolutely right there, Alex. Confirmation ASB grounds 1 and 2 is the new notice provision 28 days. No, if it's ASB, it's forthwith, because you've got the ground 2, and that's a crucial point. You've got ground 2. Will a court hear? Oh, that's the one you just said. Will a court hear a 1 to 3 day case remotely? Does a paper review hearing actually involve the parties? Well, of course, it doesn't in the sense, for example, of an accelerated procedure claim. But of course, it's not too difficult for a case to be pushed to the court because the judge is unclear about some matter. But and in those circumstances, for example, if the tenant has objected to the possession claim, the court would normally pass it to a hearing anyway, and you get into the whole hearing rigmarole that Olivia talked about there on in. Anyone seen anything else? I don't think so. Lots about notices. I'll come up to the, good Lord, there's 48 questions. I'm going to go right to the bottom just to make sure I really haven't. No. Has anyone seen anything else that we really haven't answered? I mean, can I just say in summary, it seems to me, and everyone has their say on this, it seems to me that the big issue is notices. Everything else, yeah, I mean, the reactivation notices and the paragraph 6 notices that you explained, Alex, you've got to go through them and the court may lose them and whatever else, but, you know, we'll get through that. It's the notices that have been the changes to the Coronavirus Act, Schedule 29. It's the big thing. That's the big thing here. Getting the right notice, deciding which is the best route to go down, because that may impact upon how long you have to wait before you can issue proceedings. That's the key, and that's the key to the government's strategy about acknowledging they've got a backlog. They're not going to be able to hear as many cases as they did in the past because of these problems of remote hearings and not enough judges being in the courts and so on. And that's the crucial bit. And therefore, one needs to look very much at Schedule 29 of the Coronavirus Act. That is the key to it. All the other documents are really important, but that's the key to this process and to any decision making that goes on. And the only other thing I would say is that, and this is something that Olivia said, particularly with social landlords, it seems to me crucial, just as you would do with antisocial behaviour cases, it seems to me crucial that you up front say what you've done to find out about the tenant and their household's circumstances. Of course, you would have done that in most instances anyway, and you'll be well aware of what their circumstances are. But you have made a genuine effort, whereas for a private landlord, they've already wasted a lot of money. They're not going to waste any more money. For a social landlord, I think it's very different. And I think if a court knows that there's been the emails, there's been the text messages, there's even maybe been the visits, just to see, is there any particular reason why things are going so bad, particularly on rent arrears cases, for example, and to see if there are any health issues, coronavirus or whatever. It seems to me that there is a good sense, as Olivia said, to do a very short statement to accompany the claim form, which, remember, can be issued now just as it was always could be issued. It's important that that is done to try and explain to the judge in advance, and even in addition to the reactivation notices and the paragraph 6 notices under 55C, that the case should proceed and not allow a judge an excuse to say, well, I don't really know what you've done, and I'm not sure you've made enough effort. And, you say you haven't seen this person for 3 months. Well, maybe they're suffering and and you can then say, well, look, no, we've done all this, and it seems to me that's one of the most important things. And I think that's what, get the notice periods right, look at Schedule 29 and really kind of think as social landlords, how you've liaised with your client and why it's important that you really go for possession at this stage. Does anyone else have any overarching kind of comments on what to do on 20th of September? No? Well, look, can I just thank everyone for joining this webinar? It was very well attended, and I really do appreciate that. I'm sure we're all, and you'll see them on screen, shaking their heads if it's not right. I'm sure we're all happy to answer quick queries. But as I indicated, I'm more than happy to send out forms, that table I talked about, to people if they emailed me, and the email's on the website, and it's andrewell@cornerstonebarristers.com. But I'm sure we're all happy to do that. So if something comes up that we haven't answered, that I haven't been able to read properly, please feel free to email us and ask us a question. The other thing I would say in parting is, can you also, it'd be really interesting to know, because we'll no doubt do other of these courses, let us know what's actually happening in practice, particularly post 20th of September, because there's going to be a lot of war stories. And I do think, it's going to be interesting to know some courts will be very efficient and some courts will be, less so. And therefore it'd be very interesting to know what actually happens. So we are now 12:30. I need to go to Marks and Spencer. Oh, no, it's advertising. I need to go for my lunch. So thank you very much, as I say, and hopefully we'll see you at the next webinar. And we'll see you in particular on the Housing Week, which we're holding in October of this year, where instead of a housing day, our annual housing day, we're having a week of conferences, webinars every day of the week in the early October. So have a look at our website for that. And thank you very much. So I'm going to log off now.